Alright. Punta naman tayo ngayon sa remedies. So, the following are the remedies to the government in the stage of assessment and collection. So, number 1, normal or ordinary assessment and collection. This is only available to the government if there was a return filed by the taxpayer and such return is not false or fraudulent. Take note that here, the return filed by the taxpayer is not false or fraudulent. So, the government may make the assessment within 3 years after the last day prescribed by law for filing the return and not from the time of payment. Again, take note of that. Take note of that. So, if the return is filed beyond the period of filing prescribed by law, the 3-year period shall be counted from the day of the filing of the return. Prescription period for collection is 5 years from final assessment. Number 2, abnormal or extraordinary assessment and collection. So this remedy is resorted in cases where the taxpayer omits or fails to file his return. The taxpayer files a return, but the return was fraudulent. And the return filed by the taxpayer was false. You have to take note that the legal presumption is that the return filed by the taxpayer is true and correct. Therefore, the burden of proof lies in the government to prove that such return is fraudulent or false. Again, the legal presumption is that the return filed by the taxpayers is true and correct. At ang burden of proof lies in the government to prove that such return is fraudulent or false. So, another one. These are the remedies or the options available. Assessment and collection. For assessment and collection, the prescriptive period for assessment is 10 years from the discovery of the non-filing of the return or the fraudulent or false return. The period for collection prescribes in 5 years from the date of final assessment. Okay, ilista nyo yung mga prescriptive periods, okay? Dahil masyadong madaming dito mga prescriptive periods, baka magkabali-baliktad. For example, ito, yung assessment 10 years from discovery. Dito sa period for collection, nagpe-prescribe naman siya in 5 years. Kailan ang reckoning point nung sa assessment? From the discovery of the non-filing of the return or the fraudulent or false return. Dito sa collection, ang reckoning point is from the date of final assessment. Okay? So, for collection without assessment, there's no prescriptive period for assessment. Prescriptive period for collection is 10 years from the discovery of non-filing or fraudulent or false return. Letter B, procedure for assessment. Paano ba to? So, Section 228 of the NIRC provides for 2 steps for assessment. Ito yung 2 steps for assessment. Number 1 is pre-assessment notice, and number 2 is final assessment notice. So, RR number 12-99 provides for 3 steps, namely, notice of informal conference, preliminary notice of assessment or PAN, and formal letter of demand and notice to pay the tax or FAN. Okay, so kung mapapansin nyo, dun sa NIRC, Section 228, dalawa lang yung steps for assessment. Dito sa RR number 12-99, merong 3. Okay, so ilista nyo din yan at pag-aralan mabuti. So, for pre-assessment notice or PAN, this is issued to a taxpayer who fails to file a return, or files a return but fails to pay the tax, or files a return, pays the tax, but such payment is insufficient, so kulang. The following are instances where PAN is not necessary based on Section 228. Number 1 is mathematical error in computation. Number 2 is discrepancy discovered by the withholding agent. And lastly, when a taxpayer who opted to claim a refund or tax credit of excess creditable withholding tax for a taxable period was determined to have carried over and automatically applied the same amount claimed against the estimated tax liabilities for the taxable quarter or quarters of the succeeding taxable year. So, these are the instances kung kailan hindi na kailangan ng preliminary assessment notice. Another one ay when the excise tax due on excisable articles has not been paid. Ito pala yung last. So, maliban dun sa tatlo na sinabi natin kanina, may pang-apat at pang-lima pa. Yung when the excise tax due on excisable articles has not been paid. And number 5 is when an article locally purchased or imported by an exempt person has been sold, traded, or transferred to non-exempt persons. Examples given ay vehicles, capital equipment, machinery. So, for final assessment notice or FAN, ini-issue to pag the taxpayer having received a pre-assessment notice fails to respond within the period provided by the rules under the 5 instances enumerated under Section 228. Again, itong FAN or the final assessment notice, ini-issue lang to pag si taxpayer, pagka-receive ng PAN or the pre-assessment notice, hindi or nag-fail na mag-respond within the period provided by the rules. Number 3, we have protest. So, after receipt of the FAN, the taxpayer cannot immediately appeal to the Court of Tax Appeals. The code mandates that before such appeal can be made, a protest must first be filed by the taxpayer. Again, before appeal, kailangan magkaroon muna ng protest na i-file si taxpayer. So, ano pa yung protest? Protest is an action disputing the final assessment. This is in accordance with the principle of exhaustion of administrative remedies. So, the BIR is given 180 days within which to decide on the matter. Upon denial of the protest or the lapse of the 180-day period without action from BIR, the taxpayer may now appeal to the CTA within 30 days from receipt of the denial or lapse of the period. So, only when na-deny yung protest or naglapse yung 180-day period at walang action on the part of the BIR that a taxpayer may appeal to the Court of Tax Appeals. If no appeal is made, then the decision shall be final, executory, and demandable. Punta tayo sa appeal to the Court of Tax Appeals. So again, upon the denial or lapse of the 180-day period, pupunta ka naman ngayon sa Court of Tax Appeals Division para mag-appeal. So pending appeal, the BIR may amend the assessment during the pendency of the appeal to avoid multiplicity of suits. After sa CTA, punta ka naman ng Supreme Court kung hindi favorable yung decision ng CTA. So, if the CTA's decision is unfavorable, the taxpayer may file an MR or a motion for reconsideration within 15 days from receipt of the decision of the Court of Tax Appeals sitting in division. So, if the decision in the motion for reconsideration is still unfavorable, pag talagang minamalas ka nga naman, di ba? You have to elevate the appeal to the Court of Tax Appeals and bank. If the decision of the Court of Tax Appeals and bank is still unfavorable, to super malas ka, the taxpayer is given the remedy to file a petition for certiorari to the Supreme Court under Rule 65. So, only grave abuse of discretion amounting to lack or excess of jurisdiction can be a ground for petition. Again, para makapag-file ka ng petition for certiorari sa Supreme Court under Rule 65, ang ground mo lang na pwedeng gamitin ay grave abuse of discretion amounting to lack or excess of jurisdiction. So, objections to assessments should only be raised to the BIR as well as the CTA and not via petition for certiorari. The final assessment becomes final and executory when the protest is not filed on time, when the supporting documents were not filed within the 60-day period, when no appeal was filed to the Court of Tax Appeals within 30 days after the lapse of the 180-day period, and there was an appeal filed but such was beyond the period to appeal. Ano ba yung mga forms ng protest? Number 1, we have the protest under the local tax. The local government code provides that when the local treasurer finds that correct taxes, fees, or charges have not been paid, he shall issue a notice of assessment stating the nature of the tax, the fee or charge, the amount of deficiency, the surcharges, interest, and penalties. So, the taxpayer may file a protest within 60 days from the receipt of the notice of assessment. The non-filing will make the assessment final and executory. The local treasurer may grant the protest wholly or partially or partly, or deny the protest wholly or partly. The taxpayer is given a period of 30 days from the receipt of the denial or the lapse of the 60-day period within which to appeal to the Court of Competent Jurisdiction, the RTC, or the Regional Trial Court. In case the Regional Trial Court renders an unfavorable decision, the taxpayer may appeal such decision to the Court of Tax Appeals, sitting en banc. Then, if the decision is still unfavorable, you have to elevate the case to the Supreme Court. In case the decision nga of the CTA or the Court of Tax Appeals en banc is unfavorable. So, protest under real property tax. Yung kanina, protest under local tax, ngayon naman, under real property tax. So, it is made by the taxpayer who is not satisfied with the action of the assessor in the assessment of his property. The taxpayer has 60 days from the date of receipt of the written notice of assessment to the appeal to the LBAA. And what do we mean by LBAA, the Local Board of Assessment Appeals? So, before this protest may be entertained, the local government code requires that the taxpayer first pays the tax. This is referred as payment under protest. So, the protest must be filed within 30 days from the payment of the tax. Here, the local board for assessment appeals shall decide within 120 days from receipt of the appeal. And the burden of proof required is substantial evidence only. In case the local board for assessment appeals renders unfavorable decision, he may appeal to the central board for assessment appeals. So, if the central board for assessment appeals likewise renders an unfavorable decision, the taxpayer may appeal to the Court of Tax Appeals and thereafter to the Supreme Court. How about protest under the Tariff and Customs Code? Under the Tariff and Customs Code, if the importer loses the case, his remedy is to appeal the decision within 15 days before the commissioner. In case the commissioner decides in favor of the government, the imposter may file an appeal to the CTA sitting in division within 30 days from receipt of the decision. If the Court of Tax Appeals decides in favor of the government, the importer may file a motion for reconsideration before the same division within 15 days. In case of unfavorable decision from the Court of Tax Appeals Division, the importer may appeal before the Court of Tax Appeals sitting en banc. In case the importer still fails to have a decision in his favor, he may appeal to the Supreme Court within 15 days from receipt of the unfavorable decision. A second situation is provided in case the importer taxpayer prevails over the government. There will be an automatic review within 5 days. For filing, the Secretary of Finance, in case the value of the commodity is 5 million above, and Commissioner, if the value of commodity is less than 5 million. So, above 5 million, si Secretary of Finance ang magpa-file. Below 5 million, si Commissioner. The Commissioner is given a period of 30 days within which to decide. If the Commissioner reverses the ruling of the collector and renders a decision in favor of the government, such decision shall be final and executory. If the Commissioner affirms the collector or does not render a decision within the 30-day period, there shall be automatic review before the Secretary of Finance. The decision of the Secretary, in case it is unfavorable to the importer taxpayer, shall be appealable to the Court of Tax Appeals. It is the decision of the Secretary that is appealable to the Court of Tax Appeals. Okay, let's now proceed to compromise. The Commissioner may compromise the payment of any internal revenue tax under two instances. A is when reasonable doubt as to the validity of the claim against a taxpayer exists. B is when the financial position of the taxpayer demonstrates a clear inability to pay the assessed tax. So, may the government compromise both criminal and civil cases? So, in civil cases, the government may compromise the liability of the taxpayer at any stage of the proceeding, except when the case is already final and executory. In criminal cases, compromise is also allowed, except if the criminal case is already filed before the regional trial court or if the case involves fraud. Question. Supposing the civil case is already final and executory, can it still be subject to compromise? If this would be allowed, the doctrine of separation of powers will be violated, so no. Supposing the corporation is already dissolved, can the stockholder still be compelled to pay the tax liability? The answer is no, except in the following cases. So, as a general rule, no. But we have these exceptions. Number 1 is if there is evidence to prove that the assets of the corporation were taken by the stockholder. Number 2, if the stockholder has an unpaid subscription. Here are the limitations on compromise agreements. For cases of financial incapacity, the minimum rate shall be equivalent to 10% of the basic assessed tax. For other cases, the minimum rate shall be equivalent to 40% of the basic assessed tax. You have to take note, where the basic tax involved exceeds 1 million or where the settlement offered is less than the prescribed minimum, the compromise shall be subject to the approval of the evaluation board. So, yung evaluation board is composed of the commissioner plus 4 deputy commissioners. So, remedies for collection of delinquent taxes. We have judicial action, civil action, and criminal action. We also have administrative action, distraint, levy, and tax lien. Also, we have distraint. So, constructive distraint. If delinquent taxpayer is retiring from any business subject to tax, if the delinquent taxpayer is intending to leave the Philippines, if the delinquent taxpayer is intending to remove his property in the Philippines, if the delinquent taxpayer is intending to hide or conceal his property, and if the delinquent taxpayer is intending to perform any act to obstruct the proceedings for collecting the tax due or which may be due to him, then the proper remedy is distraint or constructive distraint. You have to take note that the subject of the distraint is the personal property of the taxpayer, and distraint is affected by requiring the taxpayer or any person having possession or control of such property to sign a receipt covering the property distraint and obligate himself to preserve the same intact and unaltered and not to dispose of the same in any manner whatever without the authority of the commissioner. In case the taxpayer refuses to sign the receipt, the revenue officer can just leave a copy in the premises in the presence of 2 witnesses. In case of distraint of intangible properties, such as stocks and other securities, a copy of the warrant of distraint shall be served upon the taxpayer and upon the president, manager, treasurer, or other responsible officer of the corporation which issues the stock certificates. In case of debts and credits, a copy of the warrant is left with the person owing the debts or having in his possession or under his control of such credits or his agent. In case of bank accounts, it shall be garnished by serving a warrant of garnishment upon the taxpayer and upon the president, manager, treasurer, or other responsible person of the bank. In case of actual distraint, the personal property of the taxpayer is physically taken by the distraining officer. Within 10 days from the receipt of the warrant, a report on the distraint is submitted to the RDO and RRD. So, the property distraint shall be sold in public auction. So, the time of sale shall not be less than 20 days after notice to the owner or possessor of the property. Levy. So, this remedy is applicable to real property. Levy may be simultaneous or after the distraint of personal property. Written notice shall be made or served upon the regional director of the place or the revenue director of the revenue district of the place where the property is located and upon the delinquent taxpayer, his agent, or the manager of the business. So, you have to take note that at any time before the day fixed for the same, the taxpayer may discontinue all proceedings by paying the taxes, penalties, and interest, or the right of preemption. Unlike in cases of distraint, in cases of levy of real property, the taxpayer has also the right of redemption. Redemption price is redemption price is equal to the amount of public taxes, penalties, and interest thereon from the date of delinquency to the date of sale. If there is no bidder, the property shall be forfeited to the government with 1 year redemption period. In case there is a bidder and the bid is not enough, the rules on restraint of personal property and other real property shall be applicable. You have to take note that in case of forfeiture, the title to the property is automatically transferred to the government after registration of such forfeitures with the revenue district, while in cases of restraint, the title to the property is not automatically registered. In case of injunction, the NIRC prohibits any court to have the authority to grant an injunction to restrain the collection of any NIRC tax, fee, or charge. By way of exception, the Court of Tax Appeals is authorized to issue writs of injunction for NIRC taxes. Tax lien. So in case where the taxpayer neglects or refuses to pay an internal revenue tax, the amount due shall constitute as a lien in favor of the government. The tax lien shall not be valid against any mortgagee, purchaser, or judgment creditor until the notice of such lien is filed by the CIR to the RD. Thus, before such lien can affect the rights of the mortgagee, it should be registered first with the RD. Otherwise, it is the mortgagee who will prevail over the government. Dito, RD is Registry of Deeds. Next is the approval of the commissioner. Before an action, civil or criminal, may be filed in court, the commissioner must first approve such filing of the action. The commissioner may delegate powers vested in him under the NIRC to any subordinate with the rank of a division chief or higher. So the following are the powers of the CIR which cannot be delegated. Power to promulgate rules and regulation by the Secretary of Finance. The power to issue rulings of first impression or to reverse, revoke, or modify any existing ruling of the Bureau. The power to compromise or abate any tax liability. And the power to assign or reassign internal revenue officers to establishments where articles subject to excise tax are produced. So we'll stop here muna and we'll continue with the discussion next week. Thank you for listening and have a great day.